This case was appealed, that decision was appealed by the Trump Justice Department to the DC Court of Appeals. We have 13 different appellate courts in the United States. The DC Court of Appeals is for DC. It typically rules on federal government action. It's considered the most prestigious court of all the Court of Appeals courts, right below the Supreme Court. There's more vetting for this court than any other. And of the 3 judges who sat on the panel, one of them was a Trump appointee, Justin Walker. Now, I've attended a lot of oral arguments. I've participated in a lot of oral arguments as a lawyer. I've covered a lot of oral arguments as a journalist. And honestly, I'm being serious here. I don't recall an oral argument where the judges on the panel were so blatantly and glaringly opposed to everything the government lawyers were saying. Oftentimes they'll try and ask tough questions for each side. A lot of times you walk away not really knowing how they're going to rule. Sometimes you walk away knowing how they're going to rule because they were somewhat more assertive with one side than the other. In this hearing, they just badgered the DOJ lawyer, essentially rejecting aggressively everything that he was saying. And then when the plaintiff's lawyers, the immigrants' lawyers from the ACLU and elsewhere stood up to speak, they basically kept saying, we already agree with you. You don't really need to keep saying this. Here is just one of the exchanges, courtesy of C-SPAN, which broadcast the hearing. That's where I listened to it, of this Trump appointee, Justin Walker, as he essentially sides with the Venezuelans about the right of due process.
This whole pre-deprivation thing, we were talking about people being sent to El Salvador.
And by the way, this is the lawyer for one of the lawyers for the Venezuelan immigrants who's describing why due process is so urgent here. And then you'll hear the judge interject.
This whole pre-deprivation thing, we were talking about people being sent to El Salvador, one of the worst prisons in the world, incommunicado. They're essentially being disappeared. The president of El Salvador has now said maybe they're going to spend the rest of their lives there. The government has provided zero ability to bring habeases. The implications of not giving people a chance to contest it are extraordinary. I mean, every religious and ethnic group in this country has at some point been tagged as associated with a criminal organization. If people can just be picked up and sent.
Mr. Galern, I mean, I just have to stop you. You're not getting an argument from this bench so far today against the idea that every single member of this class can have an individualized habeas determination in front of an Article III judge to say, I'm innocent.
But it's really an extraordinary thing that's happening because people were rushed out, as Judge Boasberg said, and story after story is now coming out that people had nothing to do with the gang. And so I think we're looking at people now who may be in a Salvadoran prison the rest of their lives. And I think that's really the problem. And incommunicado, families can't reach them. There's no way to reach them. And the government wants to continue doing it.
This is what I mean. You hear what he said, the judge. This is the crux of the case. Their only argument is, look, we don't dispute the government's right to deport people in the country illegally. We don't even dispute their right to imprison people if they're part of a criminal gang or an organization designated as a terrorist organization. What we're arguing is that the people accused, before they get thrown away into a foreign country and disappeared forever in one of the worst prison systems in the world for life or indefinitely, has to have the right, before they're put there, to appeal to a court and say, we want a hearing to demonstrate that the accusation against us that we belong to this gang is false. And the judge on the panel, who's a Trump appointee, interjected and said, I don't know why you keep talking about this, because there's no dispute from this bench that every single person that they propose to deport to El Salvador has the right to an Article III hearing before they're deported, where the evidence has to be considered. And just as one reminder, I sometimes, and this is what I find frustrating, to be honest, about the first 2 months of the Trump administration, it's a common claim within the MAGA movement that Bush and Cheney were terrible, that administration was terrible and destructive, the war on terror was wrong and bad, that civil liberties are vital. What the Trump administration is doing was the crux of the war on terror assault on civil liberties under Bush and Cheney. The argument of Bush and Cheney was that we have the power, because we're in a war called the war on terror, to unilaterally and with no review designate people, even American citizens, as terrorists or enemy combatants. And once we do that, we can do anything we want to them with no judicial review. We can torture them. We can kidnap them off the streets of Europe and ship them to Syria and Egypt to be tortured. We can put them in prison in Guantanamo for life. We can claim the right to spy on American citizens as long as we think it advances our interest in terms of battling terrorism. And when there were Patriot Act controversies or Guantanamo controversies, the argument of the government was, look, you just trust us. We have done a very thorough job of determining who these people are. We know they're terrorists. In fact, in Guantanamo, every person in Guantanamo, we were told, was not just a terrorist, but, quote, the worst of the worst. And at the time, there were in excess of 1,000 detainees in Guantanamo. Now there are fewer than 30. Because the government, over 18 years, realized that these people are not threats. They have never been associated with terrorist organizations. A lot of them were picked up based on bad intelligence or deliberate vindictive reporting to the U.S. military that somebody was, or just mistaken identity. And it was only once the Supreme Court ruled in 2008 that they have an entitlement to a hearing, a habeas corpus hearing under the Constitution, even though they're not citizens, and even though they're being held in Guantanamo. And they started to prove that, a lot of them did, that there was no evidence against them. We learned this lesson already. We should have learned it decades ago, even before that, that you don't trust the executive branch, the federal government, to say, we'll decide who's guilty. You don't need to see any of the evidence. They don't need any opportunity they can test it. We're good people. Trust us to do it. That's not the American system. That's not an American value. It never has been. Here's Patricia Millett, who was also on the panel. She's an Obama appointee. She was very active in this oral argument. I mean, again, just like badgering the DOJ lawyer, but in a way that the Trump appointee agreed with as well. And we'll just show you a couple of clips of that.
But second, I think that the procedural one still challenges fundamentally in core habeas. It says you may not do anything to me under the AEA until you satisfy these preconditions. You are utterly without power to do so. I mean, that is the same sort of core habeas as asserting that a conviction is wrong because procedural requirements in a trial were not followed.
No, I don't think that's the same at all, because people don't go through a trial in this country without getting the gold standard of due process. And that was not happening here. I think that's a false equation. The problem here is, right, that they are challenging implementation, the proclamation, in a way that never gave anyone a chance to say, I'm not covered. And if your argument is we didn't have to do that, it's an intrusion on the president's war powers, the courts are paralyzed to do anything, then that's a misreading of precedent. It's a misreading of the text of the Alien Enemies Act. And that can't be an unlawful intrusion on the president's powers. You just can't. The president has to comply with the Constitution and laws like everybody else.
On that, we certainly agree, Your Honor. I think that what has occurred.
I mean, just by the way, last week, my friends Sagar Enjeti and Crystal Ball, the co-host of Breaking Points, had a quite vociferous debate, twice in fact, about this issue, with Crystal arguing against these deportation to El Salvador and Sagar arguing in favor. I listened to both. I went and talked to Sagar and explained to him my reasons why I thought he was wrong, and to his immense credit, asked me to come on the show. Crystal's off this week on vacation, where I could basically yell at him and tell him why he's wrong. And he actually, during the conversation we had, even before this, was starting to say, you know what, maybe I'm being convinced. I'm understanding these arguments better now. He kind of said, I'm very emotional about illegal immigration, like a lot of people are. And I just want the problem solved, but it is true we can't violate the Constitution or basic due process rights to do it. And to his great credit, he invited me on. The playful title that Breaking Points put up was Glenn Greenwald's School's Saga on Deportation. A lot of people thought that that was the staff passive-aggressively rebelling against Saga. In fact, he was the one who wrote it, knowing that it would bring a lot of traffic to the segment. But we did hash it out. Ryan Grimm was there as well for about 25 minutes. And kind of at the end, Saga said, you know what, I feel like I'm probably wrong on this issue. I'm starting to understand why this can't be, that you can just throw people into an El Salvadoran prison with no opportunity for them to say that I've been wrongly accused of being part of a drug gang. Otherwise, you could just pick up anybody. The president could. Anyway, I recommend that Talking Points debate I did earlier today, because a lot of these issues are really hashed out. Here's the third segment I want to show you from the hearing, because I want to just explain this one point. The only reason that the Trump administration argues that they can ship people out of the country with no due process is because they have declared war. They claim that the United States is under attack, that it's a war like World War I or World War II or the 1812 war, which were the only 3 times in history that the Alien Enemies Act, on which the Trump administration is relying, was actually invoked for real wars, like when the United States was really at war. And they needed during World War II, for example, to expel people they thought were Nazi sympathizers or sympathizers with Japan. This was the statute that led FDR to claim the power to imprison Japanese Americans in internment camps with no evidence of wrongdoing, just based on the belief that if they were Japanese in ancestry, they would have more loyalty to Japan than to the United States. So this is a very extreme law, and there's a lot of questions about, are we actually at war with Nicaragua? Is that a criminal problem? It sounds like a criminal problem. Usually you go to war with nation states, not with drug gangs. But even when we were in World War II and World War I in the 1812 war, and the government claimed the right to expel people who were foreign threats, even they got hearings. If someone was a suspected Nazi sympathizer or Nazi operative, before they got expelled from the country, they had a hearing to prove that they were mistreated. Exactly what the Trump administration refuses to give people today. And here's what Judge Millett said about that.
Your Honor, I think this court's decision in IM versus CBP is instructive on this.
Am I wrong about anything I just said factually?
Your Honor, I think it's incorrect that they couldn't have gone into court as the 5 individual plaintiffs.
No, but the point here was that there were plane loads of people. I mean, it's a class action. There were plane loads of people. There were no procedures in place to notify people. Nazis got better treatment under the Alien Enemy Act than has happened here, where the proclamation required the promulgation of regulations, and they had hearing boards before people were removed. And yet here, there's nothing in there about hearing boards. There's no regulations, and nothing was adopted by the agency officials that were administering this. People weren't given notice. They weren't told where they were going, and they were given. Those people on those planes on that Saturday had no opportunity to file habeas or any type of action to challenge the removal under the AEA. And like you've agreed that 2 of those airplanes, people were removed under the AEA. Is that? So you kind of get a sense for how rough the Trump Justice Department lawyers had it at oral argument today. Like I said, I've never seen such a one-sided
oral argument before. There are now these issues going to the Supreme Court. The Office of the Solicitor General, which is the office that argues for the U.S. government before the Supreme Court, has appealed to the Supreme Court on the question of a district court injunction in the Northern District of California that regards whether the Trump administration has the right to fire certain government employees who had been protected statutorily with the right not to be fired without just cause. And the Solicitor General, in appealing directly to the Supreme Court, not going to the appeals court, says, quote, the lower court should not be allowed to transform themselves into all-purpose overseers of executive branch hiring, firing, contracting, and policymaking. Only this court could end the interbranch power grab. Now, I see a lot of Trump supporters arguing that district court judges should not have the power to make decisions that bind the entire federal government, the president, the executive branch, nobody elected them, et cetera, et cetera. And like I said earlier, the Trump supporters, the conservative movement, frequently went into federal court under every Democratic administration for decades, including Joe Biden's, and asked a single federal judge in a single federal court district to enjoin, to stop Biden policy, not for just one district, but for the entire country, and they often succeeded in getting it. No conservative back then ever said, oh, federal district court judges don't have the right to stop U.S. government policy. Because again, if you want to sue the U.S. government and get an injunction, stop them from doing something you believe is illegal or unconstitutional, you have to go to a federal district court. That's the only one that can rule in the first instance. And the solution, if the government thinks that the injunction is wrong, is not to ignore it, but to appeal to the appellate court, then the Supreme Court. That's how the rule of law functions. Here are a few examples from the, this is the On Data and Democracy headline. Oh, actually, this is a little bit different. This is, there's this other narrative that the judges who are ruling against the Trump administration are all left-wing judges. They're all leftists carrying out a political agenda and a political war against Trump. So this is the On Data and Democracy, which compiled data that reveals a cross-ideological judicial opposition to the Trump administration. And they have both liberal and conservative judges are ruling against Trump. 2 of the 4 judges targeted for impeachment are actually right of center. And you can kind of see here that they have the conservatives over here and the liberals over here and the center, the kind of center over here. And it's also for Trump and against Trump. And you see a lot of these people for Trump, here conservatives for Trump, who have been ruling against him. And you see Judge Boasberg, who again is being called a far leftist, even though his judicial history doesn't remotely suggest anything like that. Other judges as well who are more to the conservative side. And then you can really see it here where this is the percentage ruling against Trump by judicial ideology. And it's 76% for liberal judges or Democrats, 88% for centrist judges, and even 50% for conservative judges. So this is by no means a far left attack on the Trump administration. This is something which the judiciary is reacting to. Remember, the Trump administration, the Trump movement, and this is part of what I liked about it, vowed that they were going to go in and completely break the way things are being done. So it is, I think, expected that judges are going to be giving more scrutiny to brand new ways of doing things. One of the cases that conservatives ended up getting a federal district court to stop was Biden's plans to cancel student loans, something he was being pressured to do by the Democratic Party base. And instead of getting Congress to do it, he issued an executive order, argued he had the power to do so. Even though when Biden refused to do it for years, Nancy Pelosi said he doesn't have that power, only Congress can do it. Biden did it because he wanted to give his base a kind of political present heading into the election. And conservatives ran into a federal court, just a normal federal district court judge, and said Biden's student loan cancellation policy is illegal. It exceeds his power as a president. And they got a federal court judge, a lower court judge, to stop the policy for the entire country. They overrode the president's policy. Here was Donald Trump in a video on Truth Social in September of 2024 celebrating that ruling.
Joe Biden was just rejected with his hoax on trying to get student loans paid off or go away or whatever. It was total rejection. They laughed at him. He's a stupid man, but he doesn't care because he's not running.
So that was one example. Here, David Sachs, who I know very well and have a lot of respect for, he's been a very knowledgeable and important and influential opponent of the war in Ukraine, among other things. I think he's been really influenced by a lot of the voices that we have on our show, Professor Mearsheimer, and that kind of realist school that is opposed to intervention. But he is now part of the Trump administration. He's Trump's czar for crypto and artificial intelligence. And he said this on X earlier today, quote, "There are over 600 district court judges in the U.S., roughly half appointed by Democrats and half Republicans. Obviously, the whole system breaks down if it only takes one to invalidate any executive branch action." I just showed you Trump celebrating a federal district court judge doing exactly that, invalidating an executive branch action. But remember the case that we talked about a lot where the Biden administration was coercing and pressuring big tech to censor dissent on a whole range of issues, including COVID? And the Biden administration lost in the federal court, district court level. Conservative attorneys general for Missouri and Louisiana went in and sued the Biden administration and asked a federal district court judge to enjoin that program, enjoin the government from doing what they were doing with coercing big tech. And David Sachs, the same David Sachs who just said the government would collapse if federal district court judges can override executive policy, the country would fall apart, was celebrating this. Because like myself, he found the censorship regime to be so offensive to the Constitution and American values. Here's what he posted on X in July of 2023. Quote, "A U.S. district court has ruled that parts of the government, including FBI and HHS, cannot urge, encourage, pressure, or induce social media sites to remove content containing protected free speech. A much-needed decision. Happy July 4th. Conservatives constantly got federal district court judges to enjoin Democratic administrations. Here's Charlie Kirk today. This is Charlie Kirk earlier this month, speaking on Laura Ingram's program about why he believes the United States now faces a constitutional crisis.
So you have these district court judges, usually, Charlie, selected in areas where they know there's a disproportionate number of Democrat appointees. So they'll go to the First Circuit, go to Boston or Connecticut or D.C. or out in the Pacific Northwest, and they'll find a friendly judge, and then that judge says, okay, the president has no authority. I mean, that's just ludicrous. So the administration has to go directly to the Supreme Court on that question, and there's a process for doing that. But the DOJ and the Solicitor General's office has to push against these nationwide injunctions, because I think that's really going to be the only weapon in the first 2 years that the Democrats can deploy here.
It's the only weapon, and it is the strategy of trying to run out the clock. They're trying to flood the zone with so many nationwide injunctions that the Supreme Court cannot practically actually be able to rule on all of these cases. If there's 100 or 200 sweeping nationwide injunctions, maybe half of them will end up being heard by the U.S. Supreme Court. This is a run out the clock strategy that they tried during the first Trump administration. And so Senate Republicans, they needed to get very wise about the new litmus test when they ask these new judges that come up for hearing, do you believe that this is okay? Clarence Thomas in 2018.
Now, again, this is how our system has worked for many, many decades, more than a century. Federal district court judges are the court of first instance when you sue the government, and they have always had the power to issue injunctions. They issue injunctions against acts that are illegal or violative of the Constitution. Conservatives have used that tactic as much as liberals. This is not a left-wing tactic. And it is true that there are more injunctions against the Trump administration, but that's because the Trump administration came in extremely well prepared to issue an immense amount of executive orders from the Trump White House to implement the agenda that they had wanted to implement. And usually presidents get into office, and like I said, they tend to be interested in the continuity of the status quo, and so you don't get anywhere near the number of executive orders. Charlie Kirk used the phrase flooding the zone for these lawsuits. That's what liberals have been calling Trump's strategy, flood the zone with so many executive orders that you can't keep track of them. So that's the reason. It's a reaction, it's an action and a reaction. Here was Charlie Kirk. That was Charlie Kirk saying we have to put a stop to federal district court judges enjoining our whole government nationwide. Here he was in July of 2023, reacting to the federal district court's injunction of the pressuring of the big tech companies by the Biden administration. And Charlie Kirk said, quote, instead of simply reporting the facts that a federal judge just delivered a blockbuster injunction in Missouri versus Biden, blocking this administration from outsourcing its censorship regime to social media companies, the New York Times spins it as, quote, a ruling that could curtail efforts to fight disinformation. Pure propaganda. I totally agree with Charlie Kirk's tweet there. I covered that New York Times framing. I completely agree. I celebrated that federal court injunction because federal courts have the power to enjoin the government nationwide. The Biden administration appealed that ruling to the appellate court. They also lost in the appellate court. The appellate court said, by a 3-0 decision, this is one of the worst assaults on the First Amendment we've seen, and the government remains enjoined from doing this. And then they appealed to the Supreme Court, and the Biden administration won, mostly on quasi-procedural grounds. That's the way the court system works, and it always has. Hear from the Topolofsky Smith law firm in November of 2024, quote, federal court permanently enjoins Biden parole in place program for undocumented spouses and stepchildren of U.S. citizens. The USCIS announces that it will cease to accept and process applications under this program. So the Biden administration put in a program for undocumented spouses and children. Conservatives ran into federal court, said it was unconstitutional and illegal. The federal district court said it was. The Biden administration says, okay, we're going to stop the program. Here from the Washington Post, June of 2024, courts grant injunction against Biden's student loan repayment plan. Judges in Kansas and Missouri issued rulings Monday preventing the government from fully implementing and forgiving any more loans through the SAVE program. And that, of course, was a federal district court judge. Trump did that video celebrating it. Here from September of 2023, Phelps Dunbar LLC, the law firm, issued a release. Texas district court judge enjoins President Biden's $15 minimum wage for federal contractors order. So the government wanted to implement a policy that if you want to have a contract with the federal government, there's a requirement of a $15 minimum wage. The conservatives ran into a federal court, got a single federal district court judge to issue an injunction nationwide. They all celebrated that. Here from the law firm Sidley and Austin, August 2022, U.S. District Court enjoins the Biden administration's nationwide oil and gas leasing pause following the Fifth Circuit remand. So the Biden administration, based on the promise that they made during the campaign, wanted to pause oil drilling and gas leasing, and conservatives ran into a federal court. A single district court judge got persuaded to issue a nationwide injunction stopping Biden from doing so. Every conservative celebrated. Nobody said, what do you mean a federal district court judge can issue a nationwide injunction stopping the government? Yes. Everyone understands that's how it's always worked. I understand there are more such injunctions now, but that's because there are more Trump executive orders now. Ian Trump is not a status quo president. He's a status quo breaking president in a lot of ways. But if you want to complain about the number, complain about the number. The principle, though, cannot be challenged, which is that, of course, a federal district court judge has the right to issue nationwide injunctions stopping a presidential policy. They always have had that power. Both sides have used that power and celebrated it repeatedly. And now suddenly they want to create a new principle that federal district court judges should not have this power because it's Donald Trump now in office and they don't want to see him constrained in any way that is anything but a principled or a constitutional-based argument. What if your morning coffee didn't just wake you up? What if it actually made you younger? That's why 1775 created Rejuvenate, the first coffee infused with CAAKG, a clinically proven ingredient to fight aging at the cellular level. You're still getting that pure 1775 coffee quality, single origin beans, small batch roasting, and specialty grade coffee ethically sourced from small farms. But now, each cup fires up your metabolism, boosts your energy, and turns back the clock by up to 8 biological years in just 7 months. Yes, studies prove that. I'm not making that up. 1775 Rejuvenate officially drops on April 15th, but you can lock in your pre-order right now. And every dollar you spend still enters you to win a Cybertruck and $30,000 in cash. Head over to 1775coffee.com. Use the promo code Glenn for 15% off and then drink your age away. Thanks for watching this clip from System Update, our live show that airs every Monday through Friday at 7 p.m. Eastern exclusively on Rumble. You can catch the full nightly shows live or view the backlog of episodes for free on our Rumble page. You can also find full episodes the morning after they air across all major podcasting platforms, including Spotify and Apple. All the information you need is linked below. We hope to see you there.